the Sunshine for Regulatory Decrees and Settlements Act, it appears that any private third party could weigh in on a proposed consent decree or settlement agreement pertaining to a regulatory action that affects the rights of private parties. What is the scope of entities that could intervene in a suit to enforce statutory rulemaking deadlines under this provision, and what impact would it have on the efficacy of the rulemaking process?
Thank you, Congressman. This provision provides that any person who believes that it's in their interest, quote, who would, quote, not be represented adequately by the existing parties to the action, end quote, should be permitted to intervene in the litigation where a settlement agreement is being considered. This provision is written unbelievably broad with little limitation. It is much broader than what is currently required under the Constitution for constitutional standing requirements, which requires parties to show that they were or will definitely be injured by the agency's action, that agency delay will cause injury, and that the harm would be redressed by a favorable outcome. And the end result of this is that it will end up delaying the rulemaking process. Agencies are already required to go through a, in my mind, very laborious notice and comment process in order to ensure that the public has the opportunity to comment by allowing any party under the sun to engage in these pre-settlement arbitration discussions to try to add additional provisions. It's just going to slow everything down in an already slow process.
Thank you, Mr. Phillips. Why is H.R. 788, the so-called slush funds bill, a solution in search of a problem?
Yes, thank you again, Congressman. This settlements bill aims to address, the settlements this bill aims to address are just not problematic. No one is forcing firms to enter into settlement agreements. No one is forcing them into settlements with third-party payments. They do so voluntarily because they think that settling is a better value for them than the alternative. They could certainly proceed to trial if they wanted to, but enacting this bill would create more problems by preventing parties from voluntarily settling. If you look at the settlements entered into after the 2007-08 financial crisis, banks entered into these settlement agreements largely because of some of these third-party payments. So JP Morgan Chase settled for $13 billion, $4 billion of which was going to go towards consumer relief. A good chunk of that money Chase was going to have to pay regardless because they were going to have to do mortgage modifications and things like that. And so reducing its actual settlement expenditures to roughly $10 billion. If this bill had been in place and JP Morgan Chase had been asked to settle with a $13 billion fine directly to Treasury, I'm really doubtful that they would have settled and would have instead gone to trial. And that would have forced the Department of Justice litigators to spend a lot of time and a lot of money preparing and defending their action. And it would have just been wasteful government spending as opposed to moving on to pursuing different and other wrongdoers.
Thank you. Ms. West, the Institute for Justice's 2020 report titled Policing for Profit states that the Department of Justice's equitable sharing program, quote, creates a giant loophole, close quote. What is this loophole, and can you explain how it allows state and local law enforcement agencies to circumvent civil forfeiture laws passed by the state legislatures? Your mic.
Sorry, thank you. So with equitable sharing, even in states that have passed reforms to their own civil forfeiture laws, state law enforcement, if they work with the federal agencies, they can still get back the proceeds of civil forfeiture. And one great example for that is in Missouri. The Missouri Constitution actually has an amendment that says all of the proceeds of forfeiture should be going to schools. But because Missouri state law enforcement can still take forfeitures and hand them over to the federal government through equitable sharing and then get kickbacks of up to 80% of the forfeitures, a 2019 investigation showed that only less than 2% of the forfeiture proceeds in Missouri were actually going to Missouri schools, as is mandated by the Missouri Constitution.
Thank you, Ms. West. My time has expired. I yield back.
Thank you. The gentleman yields back, and Chair recognizes Mr. Kiley for 5 minutes.